Okay, hello class. Today I'm going to be giving you your tests only, so make sure you access the speed building beforehand. It'll be the first file in Blackboard. Okay. Proper names on your 160 lit number 1, you have Mark Hill. Okay. And so this is going to be your test number 1 at 160 words a minute for 5 minutes. The defendant, Mark Hill, appeals his conviction of murder in the first degree. The trial was to a 12-person jury with the jurors coming from a neighboring county. At the time of this crime, the defendant was an 18-year-old farmhand. He lived on the farm where he was employed. On direct examination, he testified that on the evening of March 18, he was going to drive a tractor, which had an enclosed cab from the farm to a nearby town to visit an acquaintance. He took along a shotgun and some ammunition. He could not remember why he took the gun. At some point, he turned around and headed back to the farm. Approximately 11:30 p.m. on the way back, he stopped at a large billboard sign. He testified that the billboard sign irritated him because it had a very bright light and because he confused the light with an oncoming automobile. He loaded his shotgun with 5 slugs. Then he got off the tractor and shot out the light. Then he fired the remaining 4 slugs into the back of the sign. He reloaded his gun with 5 more slugs and drove off. He testified that sometime later he realized that an automobile was following him. He turned into a side road, but the car continued to follow him. Then he saw the emergency red and blue flashing lights, and he knew it was a police vehicle, although he did not know why the police officer was stopping him. He testified that he got very scared and panicky because he did not want to go back to jail. He had been jailed for 30 days on one count of driving a vehicle while under the influence of an intoxicant. He testified that being in jail was the worst experience of his life. After he stopped the tractor, he made up his mind that he would jump off the shotgun and run in the opposite direction from the officer. The shotgun was in a carrying case on the right side of the tractor seat. He relocated the shotgun to his left, opened the carrying case, and removed the shotgun. He testified that when he looked up, he saw a flashlight. He said that he was startled and shot the officer. Later in his testimony, he said he never actually saw the officer. He said he only saw the bright flashlight. The record reveals that the officer fired 3 shots. Approximately 15 seconds later, the defendant left the tractor and ran to his farm, where he woke up his roommate. He asked the roommate for the keys to his car. When the roommate asked why, Mark Hill said he had shot an officer. They drove off in the roommate's car, but they were soon stopped by a police car. Mark Hill was subsequently arrested for having shot and killed a sheriff's deputy. On July 17, when the jury returned its guilty verdict, the trial judge asked the jurors whether this was their verdict, and she asked for a collective show of hands. All the jurors raised their hands. The defendant's attorney asked the court to poll the jurors individually, but the judge said that she had just polled them. The judge then discharged the jury. On August 27, the trial court notified the defendant and the state that the court had erred by denying the defendant's request and that the court was going to order a new trial. However, after talking with the parties, the court agreed to bring the jurors in and conduct the poll. On September 6, which was 52 days after the court had discharged the jury over the defendant's objection, the court polled the jurors one at a time. Polling the jury is a common practice. The trial judge asks each juror whether he or she concurs in the verdict. Its purpose is to allow the judge to determine whether the verdict reflects the conscience of each juror or whether it was brought about by some form of intimidation. The trial court erred on July 17 by failing to poll the jurors one at a time. In a prior case, we treated the denial of the right to a separate poll as grounds for reversal. However, that case did not involve polling the jurors after the trial court had discharged them. The question before us now is whether conducting a poll under the facts of this case renders the error harmless. Mark Hill argues that during the 52 days between the first poll and the separate poll, the jurors may have been subjected to an outside influence. We do not know whether that is true. However, whether it is true or not, the question remains whether the error was, and it's sheriff's deputy, okay? Capitalized court if you can replace judge in the sentence. So you have your 160 number 2, Mr. and Mrs. Drake, Mrs. Drake, National Guard, Mrs. Edward, Army, Mrs. Burt, Duff, POD, Aunt Duff, Merle Lynch, and B. And it's a long answer, and the question is, would you describe the trust document marked as Exhibit C? And this is going to be your test 160 lit number 2 for 5 minutes, you all. It's the title, declaration, and clarification and modification to the original trust of Mr. and Mrs. Drake. After Mrs. Drake's attorney passed away, she asked me if I knew of an attorney. Mrs. Drake had a tremendous respect for the military because her husband had been involved with the military for many years. I told her I know the Judge Advocate General for the National Guard and gave her his name. She contacted him, they met, and developed this declaration and clarification and modification. I did not see it or know the reason specifically until after I saw it. But I did know that one of the reasons she wanted to talk to an attorney after her attorney passed away was because a Mrs. Edward had just passed away, whose name appeared in the trust. Mrs. Edward was a cousin, married an Army man, coincidentally. They had been divorced. The divorce was not a happy divorce. Mrs. Edward had 2 sons. Mrs. Drake felt badly about that divorce and felt sorry for Mrs. Edward, and that is the reason she included her in the trust in the first place. There was apparently a shortage of funds. That is, Mrs. Edward did not have a substantial amount of funds herself. So Mrs. Drake then put her in the trust. As an explanation, I believe it's pertinent to say that Mrs. Drake's cousin, a Mrs. Burt, and Mrs. Edward were each recipients of a 1/3 of an estate of a maiden aunt by the name of Duff. They each received an equal amount of that estate, and that included Mrs. Drake, Mrs. Burt, and Mrs. Edward. It was not a large amount of money, but that money didn't last very long for Mrs. Edward. It is the same money, the same assets that Mrs. Drake received and developed into what is known as B in the trust account. Mrs. Drake, at some point in time, I don't remember the exact dates, but I have evidence of it, established a POD, pay on death, for each of those sons of Mrs. Edward in the amount of, at the time they were paid, it was about $50,000 apiece. Mrs. Drake commented to me on more than one occasion that these PODs were for these boys, not because of the feeling of loyalty she had to other members of the family, but because of the difficulty that Mrs. Edward had endured. But when she died, when Mrs. Edward died, there was no reason in her mind for any of the assets of their Aunt Duff to go to that side of the family. There just was no contact to speak of with these Edward brothers. So there was never, ever in her mind any intention for those assets that were to go to Mrs. Edward to go to anybody else. So she deleted Mrs. Edward's name from the trust. Therefore, that made all of that residual money go to a niece and a nephew of Mr. Drake. Mrs. Drake did not discuss whether or not she had the right to do so. She said she was doing this because Mrs. Edward had passed away. This did not have the effect of a revocation in her mind. When Mr. and Mrs. Drake established the trust, part of it was established for tax purposes, whether or not that was a benefit I don't know. The bulk of the trust was to go to Mrs. Drake's side of the family because that's where they got most of their money to begin with. Mr. Drake's mother had been ill in her later years and resided with his sister and her husband. He was very fond of his brother-in-law and very proud of the way his brother-in-law had taken care of not only his mother, but his sister. And therefore, he wanted to make sure that there were assets left to his only remaining relatives, who were his niece and nephew. They established in the trust a number of assets that they labeled the B portion and were not at Merrill Lynch, which was the residual trust to go to Mr. Drake's niece and nephew. The estate was kept at a kind of a minimum, that is, that amount that was in the will itself did not expand. It just was kept for general usage. The intent of the trust was perfectly clear in Mrs. Drake's mind and in her explanation to me, especially after Mrs. Edward passed away, that all of that portion in B, since Mrs. Edward was gone, would just become the rest of the residual and go to Mr. Drake's niece and nephew. If I might add here my interpretation of Mrs. Drake. Okay, you all, that concludes your test. Good luck. Type them up, see how you're doing, and have a wonderful day.